Welcome everybody to the Australia-German Climate and Energy College. My name's Tim Baxter. I'm one of the students here and I'll be chairing today. I'd just like to start by paying my respects to the Wurundjeri people of the Kulin Nation and their elders past, present and future, and recognise the fact that we meet today on land that was never ceded. I would like to introduce today Professor Jackie Peel from Melbourne Law School, who's also the Associate Director of the Centre of Resources, Energy and Environmental Law. Is it that way around? I can't remember which way around the E's go. Who's come to speak to us today about liability for misleading disclosure of climate risks. I'd like to ask that everyone hold your questions to the end. There will be plenty of time to get lots of questions in. And just note that today's presentation is being recorded and will be available online afterwards. On that note, I'd like to hand over to Jackie Peel.
Thank you, Tim. And they've given me a microphone here, which with the dress doesn't quite work. So I'm going to stick it here and hopefully I won't wander away in my excitement about this topic and lose the microphone. Thank you for the introduction, Tim. I also wanted to let you know that this work that's being undertaken is as part of an ARC grant where we're looking at corporate energy transition more broadly and the role of legal mechanisms, particularly under standard laws that apply to corporations, as a way of driving behavioural change by companies. It's not that long ago, really, that if you said that companies might have legal liability if they failed to disclose what they were doing on climate change, that you'd literally be laughed out of court. It used to be that climate change sat out there as sort of environmental externality and ethical issue, something that companies might deal with in their sort of public relations efforts or indeed as part of corporate social responsibility. But that environment is changing very rapidly at the moment and it's becoming a much more serious discussion about whether or not companies could actually have legal liability for failing to tell the public and their investors and their shareholders about what they're doing on climate change. So that's what I want to talk to you about today. I know this is not an audience of lawyers, either in the room or probably on the webinar. So I'm going to try and keep the legalese at a minimum. If I accidentally lapse, that's probably a time at which I'm happy to take a clarifying question. But as Tim's indicated, I'll take as many questions as you'd like to throw at me at the end about this topic. So what I wanted to do in the presentation today was to address a couple of broad topics to really give you a flavour of developments in this area. The first thing I think it's important is to understand what businesses mean when they're talking about climate risks, which might be a little bit different if you're working in a scientific field or a policy field. And also a flavour of why this has suddenly become an issue for companies. So what have the drivers been in this area? I will then give you a sort of brief overview of some of the legal obligations. I'm not going to go into detail here, but just to give you a flavour of what companies are supposed to be doing in their disclosures to shareholders and investors and the public and how climate risk might fit into that. One of the reasons that climate risk is becoming a bigger deal is because some companies are beginning to be sued overseas on this kind of issue. So I want to give you a flavour of the overseas legal developments that are being taken against carbon major companies in the US, for example. And then lastly, what might be the prospects or not for similar actions occurring in Australia. So the first topic that I wanted to engage with is what is climate risk, at least to a company director. What do they mean by that? And we get a lot of help these days at a report that's been produced by a group you may not have heard of. It's called the Task Force on Climate-Related Financial Disclosures, or the TCFD. It was set up by the Financial Stability Board, which reports to the G20 financial ministers and central bank governors. In other words, in the financial world, a big deal. And this group was set up to develop standards for disclosures around climate-related financial risks. And it applies to banks and also to companies outside the financial sector. So this group got together, they released a report at the end of last year, and it sets out some definitions of what they mean by climate risk. And essentially they divide climate risk into two categories. Firstly, the physical risk, which is probably what you're more familiar with if you work in the scientific field. Physical risks meaning the harms that climate change could bring about, the impacts that it could bring about, whether they're acute, in other words, often event-driven, weather-related, severe weather events that cause harm, or more chronic risks, longer-term shifts in climate patterns, changes to rainfall, for example, temperature and other factors. And here what companies are concerned about is how their operations might be disrupted by climate risk, how transportation or supply chains might be affected, physical assets, oil rig platforms, for example, that might be damaged, and reduce resource availability, particularly if they rely on natural resources like water, for example. Then there's a whole other category of risks that are labelled generally transition risks. And these are non-physical risks. They're things to do with the sort of social policy environment in which companies are operating. So the sorts of things I mean here are legal and policy risks. Are there going to be new laws to regulate greenhouse gas emissions and how companies might respond to those? Litigation risks, are they going to be sued? Technology risks, as we move, say, to different sorts of technologies for producing energy, are they going to have to write off existing technology investments? Are they going to have operational changes? Market and economic risks, which are about the viability of their business model. So if you're a coal producer, like Glencore Xstrata, what's the viability of that economic model going forward in a carbon-constrained environment? And reputational risks, which is about companies' social license to operate and how changing consumer attitudes might impact on the value of their product, value of the company as a whole. So here they're talking about things that could lead to lost revenue, reduced value of their assets and investments, stranded assets, which is a term you might have heard of. For example, big fossil fuel reserves that might no longer be able to be used because of carbon constraints. And reduce company value. So when you're talking to companies about climate risk, they're thinking in these dual terms of the physical risks and the non-physical risks that are really to do with how climate change impacts markets, laws, regulation and technology. So what are some of the drivers then for why climate risk has become much more of an issue and is increasingly accepted not just as an environmental issue or an ethical issue, but in fact a source of business or financial risk to companies. In other words, something that affects the financial bottom line. And there are various factors there. One is certainly being the conclusion of the Paris Agreement internationally at the end of 2015. For all its various faults and sort of ambiguities, it did set some fairly clear guidelines around temperature targets or maximum temperature thresholds that companies have interpreted as giving some constraints around what sorts of business models are going to be viable into the future. And also can be the basis for business planning around different kinds of climate scenarios. There's also more generally been a demand for information on climate risk exposure from investors and insurers. So companies themselves are coming under more pressure from those who give them money, their investors and their insurance agencies, to provide more information. So companies, these other investor companies have a better idea what their exposure is. There have also been some lessons absorbed from the global financial crisis about the problems of overvaluing assets and bubbles that can arise. You might have heard of the carbon bubble, for example, and various reports in that regard, which are about essentially that there could be stranded assets of various kinds as a result of regulatory changes to respond to climate change and a resulting loss in market value of particular assets as a result. And there are also involvement increasingly of some big financial institutions in this space, particularly the Bank of England, the Financial Stability Board under the G20, Michael Bloomberg in New York. In other words, financial heavyweights who carry a lot of credibility in the financial world of talking about this, talking about these issues and putting them on the agenda of companies. In Australia, you'd have to say that's been echoed somewhat, but not as extensively. We had a Senate inquiry into our legal requirements about disclosing carbon risk, for example. That hasn't gone anywhere in terms of new legislation, but at least it raised the issues, people made submissions to it, and it made some strong recommendations about the need for legal change. Some of our regulators have been a little bit more active on this area, in particular Jeff Summerhays, who heads up the Australian Prudential Regulatory Authority. This is the body that looks after banks, insurers and super funds. He basically put a shot across the bows to say that these are kinds of companies that need to be thinking about climate risk and disclosing appropriately. ASIC, which is the Australian Securities Investment Commission, has not been as vocal. So it's not sending out signals to companies at the moment that it's going to be looking hard at climate risk. It's sitting in the sidelines for the moment to see how these developments go. I'll also talk a little bit about some legal opinions that have been issued by respected lawyers that have sort of warned about liability, and some test cases that are being taken before the courts. So there's some of the drivers that are pushing for more climate risk disclosure. What do companies actually have to do? Well, the first thing to note is that unlike other countries, for example, the United States, parts of Europe, we don't have specific laws that require companies to say anything about climate risk. So there's nothing in the law that says companies must disclose this kind of risk. In fact, the law is pretty much the same. What's changed is the sort of circumstances around it, such that companies are beginning to understand that climate risk might be a material financial risk, and they are required to disclose material financial risks to their business. They have to do that in various kinds of forms. One of the main areas that companies make disclosures is in their annual reports. And this includes a report issued by the directors as well as their financial statements. Having statements about climate risk in these documents is important. Directors need to sign off on the director's report. So if they sign off on something that's dodgy, that's a misleading representation that they can be pulled up on in a legal action. Similarly, auditors big auditing companies like PwC who sign off on financial reports without adequately thinking about whether they're an accurate reflection of the financial risks to companies could incur liability. So the kinds of things that companies have to disclose at the moment are any material exposure to economic, environmental and social sustainability risks, and how managers or intends to manage those risks. So increasingly people say, yep, climate change fits within that. You might not have thought of that before, but that is now clearly in that area. Directors of companies also have duties under the law, under section 180 of the Corporations Law. Essentially, companies owe a duty of due care and diligence. That means they've got to act carefully with the best information available and consider the risks to the business. And so potentially those duties could extend to a duty to at least consider the possible effects of climate change on a business, and in some cases where those risks are pretty extensive, if you think about companies in the energy sector, some of our big four banks who do a lot of investing in energy sector developments, then you can see that there's going to be some kind of duty actually to take action to address those risks. Now, all of this was a little bit academic, esoteric, until an organisation called the Centre for Policy Development and I think the Future Sustainability Council engaged a QC. Now QC, if you don't know, fancy lawyer, fancy well-paid lawyer. So they engaged a commercial barrister, so he's not an environmental law convert by any means, Noel Hutley QC, to give them this general opinion on whether companies in Australia had obligations to disclose climate risks. And I'm told by those who are involved in the effort that at first he was pretty sceptical, but through the course of doing the opinion, actually reached the conclusion that yes, it's absolutely conceivable that you need to disclose these risks. So what's interesting about the opinion, you can find it online. It's actually written in pretty much plain language, so it's pretty easy to understand. He steps through these steps. He says that climate change risks are capable of posing foreseeable risks of harm to Australian company interests. Now that might sound like a pretty average kind of conclusion, but in the law, foreseeability has a particular kind of meaning. So to say that a risk is foreseeable means that it's something that if you don't act on it, you could be liable for resulting harms. He also says that these kinds of risks, climate risks, are relevant to duties that directors owe under the law of care and diligence to the extent that they intersect with company interests. And here's the point where he says what's really important is to look at the materiality of climate change to the risks for the business. So it's not going to be every single company that's going to be needing to disclose extensively on climate change. But if you look at the business operations, and climate change is going to affect supply chains, it's going to affect operations, it's going to affect assets, then it's something that should be being disclosed. He also goes through and looks at banks and energy companies in particular and says that company directors can, and in some cases should, be considering the impact of climate change on their business. And the final conclusion is that it's conceivable if if directors fail to consider climate business risks, they could be found liable under corporations law for a breach of those duties. So again, another shot across the bows that this is not some fairy tale kind of idea of company liability for failure to consider these risks. It's actually conceivable, which is sort of legal speak for it could happen. We're not going to put our name to it that it will happen, but it's definitely legally arguable. So this is the conclusion that he reaches. It's likely to be only a matter of time before we see litigation against a director who has failed to perceive, disclose or take steps in relation to a foreseeable climate-related risk that can be demonstrated to have caused harm to the company, including perhaps reputational harm. So for companies, this is a pretty important finding. It certainly suggests that it's better to take some steps now if they think they could be in the firing line of this kind of litigation, rather than to wait and see and be sued. So part of what increases that potential for litigation is some of the things that are going on overseas. And these have to be taken with a grain of salt because they're happening in the US. And as we know, everything that happens in the US is slightly strange. So it's not always going to be the case that there's a direct sort of transferability to the Australian context. But there have been various cases being brought. So Peabody Coal, which is probably the biggest coal mining company in the US, facing all kinds of structural problems at the moment. But it was investigated by the New York Attorney General. Basically, they looked at the annual report filings that they'd put into their regulator there. And it was found that these disclosures misled shareholders. And essentially, there was a couple of things that they'd done that they said were misleading. One was understating the level of impacts of climate risk for their business. This is quite common in annual reports that companies will just sort of say, we know climate change is out there, could pose a risk for the business. It's a bit uncertain. We're a coal miner, but we don't think the impacts are very certain. We'll know in the future. So that kind of understatement of impacts can be misleading. The other thing was that Peabody claimed an inability to be able to predict the financial impacts of future climate policies, despite an internal consultant's report, which was actually doing exactly that. So they were saying something different from what their own internal consultants were saying. And they also had in international energy data, you've seen some of the projections they make about sort of energy profiles into the future, demand for fossil fuels and so on. Basically, Peabody was taking the most optimistic scenario, a business as usual scenario, and saying, this is what's going to happen in terms of its projections. So that was found to be misleading. Another company in the firing line in the US is ExxonMobil, not least because the Secretary of State was formerly head of ExxonMobil, so it's a good political target as well as legal target at the moment. So again, there's investigations underway by attorney generals in California and New York. So those are investigations under their state laws around disclosure. And again, there's a claim that the company is repeatedly and deliberately concealed from investors the financial risks associated with climate change. There was also an investigation launched by the regulator, which is the Securities and Exchange Commission, that was essentially investigating Exxon's reporting practices and how it valued assets. So one of the questions is, if you put a particular value on a fossil fuel asset that's not taking into account climate risks and particularly transitional risks associated with devaluing of that asset, is that misleading? It's not quite clear where that SEC investigation is going now. Trump's got a new appointee to the SEC, so that may all disappear. And the ExxonMobil, subsequent to this, wrote down the value of its Canadian tar sands assets, which seemed to be an attempt to diffuse this kind of investigation. But in the meantime, ExxonMobil shareholders have filed a class action, which is a big lawsuit with many plaintiffs involved against the company. And they're alleging that it misled its investors and the public by failing to disclose climate risks. So mostly that they're saying we as shareholders were paying inflated prices for your stock because you weren't appropriately valuing in the cost of dealing with climate change and the impact on your business. So that's in Texas federal court at the moment. It was filed in November 2016. It's ongoing, and Exxon is fighting it tooth and nail. There's also, not in the corporate law sphere, but more generally, there's Californian lawsuits going ahead against various being brought by various Californian coastal communities who, like many coastal communities in Australia, are seeing the first-hand effects of sea level rise and associated problems. So this is showing an area in San Mateo County in California where properties are falling off the cliffs. They're suing carbon majors, a variety, Shell, Exxon, Chevron, for example, for climate-related damage from fossil fuel products. So there's a variety of things going on that are targeting the legal liability of companies for climate risk. I wouldn't want to represent to you that these lawsuits are all going to be successful, but they can bring about behavioural change even without being a success in the courtroom, because companies want to do something to try and minimise risks of being sued and the reputational cost that that has for them too. So what are we going to see in Australia, if anything? Well, in looking at this question, one of the things we did in our research was to take a look at what companies are currently reporting about climate change in their annual reports. And there's a variety of other reports that companies produce called sustainability reports or various other things. The annual reports are the key ones. They're the ones to which the legal liabilities attach. Currently, you'd have to say it's highly variable practices of reporting across energy companies. We looked at those in the energy sector, sort of big miners, big energy utilities. Some are sort of doing well, or at least doing a lot. I'd put BHP in this category, which has a lot of reporting around climate change and things that it's going to do differently. Not a lot of that goes in the annual report. A lot of it goes in other documentation. So if you were trying to pin them down to particular claims, as a legal matter, a little bit more difficult. And then there's others at the other end who have the kind of boilerplate or general statement: climate change is a risk, it's too uncertain, policy environment's too uncertain, we can't make accurate predictions about what's going to happen. So we've got the full range, and you'd have to say that on most measures, Australian companies are lagging in terms of their levels of disclosure, mainly because there's a lot of uncertainty about what the legal requirements actually are for companies operating in the Australian environment. So there's a couple of things to consider. So you might look at, if you're looking at these sorts of annual reports, what positive statements have been made by the company. So a lot of the time they make statements to convey the impression that they're managing the risk really well. Are they actually doing so on the ground? They might use data selectively. So they might use scenario planning or stuff from the International Energy Agency in various ways that downplays some of the assumptions underlying that data or doesn't fully reflect all the uncertainties. There's often inconsistencies across companies, across sectors. So why is one company saying there's lots of climate risk and making changes to its business and another one's doing nothing? And there's often a failure to comprehensively discuss risks. They often selectively focus on one aspect. Another thing that companies are increasingly paying attention to is what scenarios they use in planning. So if you look through, and the only scenario that seems to be being used is a sort of business as usual scenario resulting in a 3-degree or more temperature, global average temperature rise, then that's the kind of thing that you can say, well, look, how is that consistent with Paris Agreement requirements or Australian legal requirements to have that kind of scenario used as the basis for calculating risk? So the other thing that's happened recently is that environmental groups are starting to get into this space, particularly just down the road from here. The Environmental Justice Australia has a sort of program looking at exposure of companies under corporations and securities laws to actions around climate change. They brought a lawsuit against the Commonwealth Bank of Australia. It was at the time when Commonwealth Bank was fending off all kinds of other allegations about wrongdoing, money laundering, for example, and they also had this lawsuit brought against them. And essentially there are a couple of shareholders that the Environment Justice Australia was supporting who put in an argument to the federal court saying essentially that climate change poses material financial risks to the bank's business that should have been disclosed to investors. And they sought declarations, in other words, a ruling from the court to say that this state of facts existed. But they discontinued the proceedings, and part of that was CBA's reaction to these claims. So soon after they were filed, in the annual report that CBA produced after that, it had some new acknowledgements in there as climate change is a material financial risk and promising that it would undertake climate scenario analysis of its business. So you'll need to look closely at the next annual report to see how much that's taken up. And for the plaintiffs involved in this case, another important output was that the bank clarified its position in relation to funding of the Adani Carmichael mine, sort of finally ruling out funding, extending any finance to that mine as other banks have done. So it had been sort of playing, CBA had been playing around the edges of maybe, maybe not, but as a result, soon after this particular decision, they made this announcement. So you could say that there's been some effects of the lawsuit in that regard. More generally, we're going to see a proliferation of these kinds of cases. My cautious legal perspective would be certainly possible, but there's not a high likelihood of an explosion of these lawsuits. There's a couple of reasons for that. One is that we haven't sort of got engaged regulators just yet. We haven't got the Australian Securities and Investments Commission out there saying that they're going to prosecute companies if they're not doing this. So they're not sending strong signals. And if the if the regulator doesn't bring these kinds of investigations, then it would be up to private shareholders to try and bring those kinds of actions. And in order to be able to bring them, you need to be able to show there's been some harm from what the company's done. So it hasn't disclosed something, how has that caused harm to shareholders? The most obvious way that shareholders suffer harm is through a price drop in the value of their stocks. So this might occur through a write-down of a particular asset, big coal mine you were going to develop, but you're not going to anymore. You have to write off that asset. There might be a price drop for the shares as a result of that. So in a way, it's a little bit circumstance dependent. At the same time, business culture and the climate regulatory landscape, even in Australia, are rapidly shifting. There's a clear sense that even if you don't have to disclose climate risk as a matter of strict law, there's little downside to doing so and much potential upside, as the QC who issued that opinion suggested. In other words, it's a good risk management technique for companies to be doing more in this space. There are also some opportunities, I think, for proactive action by companies and for those who want to help companies be more forward-thinking in this area. And one in particular is this report that I mentioned of this task force on climate-related financial disclosures, this G20 bigwig financial institution body. Its report contains an annex that recommends that companies do various kinds of disclosures, one of which is to describe the resilience of their company's strategy, taking into consideration different climate-related scenarios, including a 2-degree or lower scenario. In other words, companies are getting a push from this to do better modelling, stress testing of their portfolios and their operations to see how they'd fare against various kinds of climate scenarios. And this body, even though you might think, well, this is the G20, some international body, are Australian companies going to take any notice? Actually, yes, they do. And even more so, their auditors do. So those who seem to be most excited about this at the moment are the accountants and auditors who are very serious about making sure they want to have compliance with internationally recognised standards around risk disclosure. So I think you can see this is going to be a space where there will be more demand by companies for better scenarios and then how that fits into their stress testing of their operations. So that's all I have to say on that topic, but I'm very happy to take questions. And I also wanted to just put up the upcoming seminars for Malte, since he asked me to do that. But I'll hand over to you if you've got any questions that you'd like to ask me.
Jackie, do you want 2 seconds to have a glass of water while I field questions?
Oh, no, it's okay.
All right. We've got a few hands that have bolted up very, very quickly.
And if you don't mind just telling me, you know, who you are, where you're from, that's helpful for me in context setting in the response.
Wonderful. Okay, so I might start down the front here. We do have microphones if because we're streaming online. If I can ask you to hold until the microphone's in your hand.
Is it on?
Yes.
Yeah, my name's David O'Neill. I run my own company called Powerless Proprietary Limited, and I've been involved in campaigns around things like the Adani mine. Look, consultants, they outsource their environmental impact statements to consultants. I mean, what sort of liabilities do we expect will flow to consultants who've historically been seen as a source of professional indemnity?
Yeah, it's a slightly different issue. In this case, the consultants would be, you know, sort of auditing companies and so on, but it's the same kind of issue. Courts in the past have been prepared to hold consultants liable for various kinds of misleading statements that are made in statements, environmental impact statements, for example, about the level of environmental risk. I think there's concern in this area from auditors and from those who prepare the financial statements in particular, that they need to be more careful around valuing assets, in particular in these kinds of statements, because they sign off on these statements as a sort of legal matter, and therefore misrepresentations could be brought home to them. So I think in that space, there's a lot of scope for consultants of various kinds, particularly financial consultants to companies, to also incur liability. And that might be a bigger driver in some cases than company behaviour, because those consultants might be more risk averse.
And we have down the back here.
Okay. Frank Yotzo from the ANU. Hello, Jackie. I'm sorry,
Hi.
I missed the start of your talk. Maybe you covered this, but are there historical precedents where legal aspects of company directors' liability have really changed the way that companies operate and what private industry invests in? And if we can ask for your sort of gaze in the crystal ball, in 10 years' time, will we think this was important for climate change or not?
Well,
for action on climate change?
Yeah, so to answer that question, there have been some precedents in other areas around divestment from certain kinds of assets on social ethical grounds, most particularly sort of the campaigns around apartheid and divestment from assets in South Africa and Zimbabwe. So there is some precedent in that regard. One of the questions that arises is if companies in particular divest from fossil fuel assets, are there others that come in and just occupy the space, less ethical investors? So that's one of the open questions at the moment. In terms of legal precedents, there's not many in this area, and certainly none that have tested requirements to disclose environmental and climate change related risks. So looking into the crystal ball, which is always a dangerous exercise, particularly when you're a lawyer, try to avoid that. But I think particularly since the Paris Agreement, there's been a momentum around this. And what's interesting has been, I think that it's a new thing to think about for companies, climate risk, compared to governments. And that we found that they're much more responsive than talking to many government departments who are a little bit like, oh, we've already considered this for the last 20 years, we're doing the right thing. So because I guess there's the potential for personal liability of directors in this space, people are much more concerned about ensuring at least that they've done the due diligence. So that's going to be things like making sure they consult widely, that they talk to experts, that they make disclosures, that they maybe change internal business practices. Does that lead to more than window dressing? Hard to say. And particularly for companies that have a business model that's based on fossil fuel development, there's really no win for them in they can disclose more, but that's sort of a fundamental existential challenge to their business model. So you can expect them to be sort of resisting along the way. Probably the greatest scope for movement is in the diversified companies that have, say in the energy sector, some room to move in terms of what they're investing in.
We've got, well, wow, that multiplied quickly. I'll go down the back corner because I think yours was one of the first hands to shoot up.
Thank you. Keith Burrows, science teacher. Seems to me that one of the companies that's misleading its shareholders, and not just them, but the rest of us, is the Murdoch media. Do you see any possibility of an action against their consistent misinformation?
I'd have to say that you're taking me far out of my realm of expertise. So I don't think so. The sort of companies that are the focus here are around companies who are actually disclosing the kinds of risks to their businesses. There are broader laws around misleading statements and so on. The media usually gets away with most things by saying it's fair comment or it's opinion. As David, I can see you nodding there, having been subjected to some of these things in the past. So I can't see that happening, unfortunately. That's a broader social change, I think.
Yep, down the back.
Peter Ambrosi, I'm a sustainability advisor. Just in answer to Frank's question, go back to Ralph Nader and the changes he drove in the 60s. So the answer is corporations do change, and especially their insurers do change. So that's the answer. But going back to your thing, presentation, and I'm particularly about the coastal communities claim. Is any part of that claim what was common law nuisance? And I think there are other actions happening in the US, and I think there's one in the Netherlands happening as well. And the reason I raise it is if there is common law nuisance, all of a sudden you have penalty damages.
Absolutely. So just a comment on the insurance aspect. Obviously, insurers are seen as a particular group of companies that might be more responsive to climate risk concerns because of the financial impact on their business model. And insurance companies also offer to directors and officers liability insurance. So one of the concerns is if you're not taking into account climate risk and properly disclosing it, are you not going to be able to renew your D&O policy? So that's another factor there. In terms of the broader landscape of climate litigation, it's very rich at the moment. So the Californian cases that I mentioned are in fact looking at theories of nuisance, which is a sort of standard legal tool based on are you causing harm to your neighbours? And Tim is kind of an expert on some of the cases that have developed in that area, including the one in the Netherlands you might have heard of called Uganda, where this group was suing the Netherlands government for basically setting its emission reduction targets too low and saying, look, on the basis of climate science and the way climate policy is developing, they should be higher, and the court agreed. There's also been a recent case in New Zealand where a law student took the New Zealand government, before it changed hands, to court saying exactly the same thing. Your targets are too low for 2030 and 2050. And the court basically agreed but said, look, but you've just had a new election. The government's coming in, the Labor coalition, who's going to renew these targets. So these kinds of cases are happening on various different theories around the world, including these kind of basic legal theories of if you cause harm to your neighbour, you should have to make compensation and pay damages. And where companies could be exposed to financial payouts, obviously that's also a liability driver or a litigation risk driver. Suddenly the lights disappeared there.
And for anyone who's interested in that, I think it's Cornell has a climate litigation database where you can look at
Columbia.
Columbia. It is Columbia. Goodness, I got the first two letters right. Columbia University Law School has a climate litigation database that has a fairly exhaustive list of all of those cases that are in progress and all the different grounds. Now, I think in terms of order of hands up, the two hands that I had up before have disappeared, so I might jump straight in here.
Michael Wheelerhan from the Victorian Department of Environment, Land, Water and Planning. I'm very interested, Jackie, in how other regulators other than ASIC and APRA might be responding to this. In particular, I'm interested in other state governments or other overseas governments that are taking up this issue and saying, well, we need to get this into our government regulatory framework. So the water sector in Victoria is the biggest commercial sector that's still owned by the state government and regulated by our government. And I'm looking at how this translates into their government's framework. So I'm curious if there are other examples that you know of where that's happened.
I'd have to say that at the moment that kind of cross-fertilisation is not occurring. So these developments are occurring in the corporate law sector, and those set of regulators don't seem to talk as much to the environmental law regulators. So I haven't seen a lot of sort of cross-cutting ideas, but a lot of our environmental legislation does have personal liability for directors of companies doing things that cause environmental harm. You could add on to that various requirements around better information about the level of risk. In the US, there has been a lot of action at the state level. But that's mainly been state attorney generals bringing investigations under their own versions of corporate laws to get better disclosures, or a state attorney general suing companies because of the damage that's occurring to the states. So it's a little bit of a different model. I think in Australia we tend to have a more regulatory approach rather than a sort of litigation approach. But I haven't seen that space sort of developing as yet. And I think it's because it's very new in this area, but also because we tend to silo off the different areas that regulators operate in as well.
I might pick the next two from this side, just try and restore some actual balance to the room or something. Otherwise the building will fall over. So.
Yeah, I'm Hans Baer in the School of Social and Political Sciences. Hans Baer in the School of Social and Political Sciences. I'm not sure if you've seen a book, a very interesting book by Chris Wright and Ben Nyberg. It's titled Corporations, Climate Change, and Capitalism. And they're two social scientists who went around interviewing corporate managers here in Australia. And they come up with the term corporate environmentalism. So whereas in the past you had organizations like the Global Climate Coalition, which was a climate denialist organization, fossil fuel companies, motor vehicle companies, and so forth, and that eventually became defunct. But what they argue is that basically a lot of this corporate environmentalism is sort of image making, that they present themselves as socially responsible corporations, but that it's a bit of greenwash. And they interviewed some of the corporate managers, and the corporate managers very often saw climate change as much more serious than the corporations were admitting, but because they were working for these corporations, they could only stick their necks out so far. So I don't know if you're familiar with that book.
Yeah.
Have you read that book?
I'm certainly familiar with the corporate environmentalism themes.
Yeah.
So just a couple of comments, because that was sort of a comment, and thank you for that reference. I'll definitely go and look at that further. But one of the aspects is that corporate environmentalism or corporate social responsibility ideas in that sphere were very much focused on the idea that you had to take environmental matters into account in the best interests of the company, but not as a sort of matter of legal obligation. I think what's really shifting is this idea that actually it also triggers legal obligations, not just ethical or reputation-based obligations. So whereas some companies got on board with disclosures around environmental issues and so on as a voluntary manner, as a matter of, as you say, of image making, this goes a little bit more hard-hitting. This is about what you actually have to disclose in legal documents, which might trigger behaviour in different ways. There still is a strong argument that's made by some scholars that this is just another form of greenwashing, that companies will settle on some formula that they use in annual reports to cover off these disclosures. And we're not yet at a stage that we're seeing enough of these disclosures that we can really say one way or the other. The other thing is as part of the project that we're doing, the next phase is an empirical phase where again we're doing semi-structured interviews with corporations to try and get a sense of, well, how are you responding to these legal developments and developments in this space? Are you making changes to what is disclosed? And we hope that that will be more enlightening. It's pretty clear though that environmental managers, particularly at the sustainability manager level, do take the issue very seriously. It's going up the chain that's more difficult. And particularly getting in front of the CFO, the Chief Financial Officer, and being able to say, well, this actually impacts the bottom line, is where you start to see behavioural change occurring.
Yep, and we'll go here again.
Okay, Jackie, thank you very much. A good talk. John Sullivan, I'm a consulting engineer. There's an interesting phenomena going on in Australia at the moment where the state governments are really pushing for quite high renewable energy targets. They would want a 50% target, where the federal government is saying, let's stick to the so-called Paris Agreement and we don't want to go above 30%. Do you think there would be any discussion going on in the Attorney General's Department right now that 10 years down the track, the federal government, as a result of science, events, etc., could be seen as being not hard enough on the environmental issues when it was being pushed very hard 10 years earlier to go to a tougher target?
I'm not going to speculate on what might be being discussed in the Attorney General's office, but to answer your question, John, I think that there are legal precedents that are now coming forward that are showing that governments can be held liable for not doing enough on climate change. There are also, and Tim knows this better than I, a range of defences under law for governments to have policy discretion. So it's in Australia, it's probably one of the hardest sorts of legal actions to bring to sue the government for effectively negligence, not discharging a duty of care to us as citizens to ensure they do the right thing on climate change, that they have proper targets. So at the moment, I'd say that the likelihood of that kind of litigation is low, and if the Attorney General was doing a risk assessment, they'd probably say, we're right, you don't have to do anything. And particularly where you could say you're complying with your Paris targets, because you know under the Paris Agreement, there's a lot of discretion given to governments about how they set their targets. Once we have the new intergovernmental panel report on the 1.5 degree pathway, we might have a bit of a greater sense around whether those targets are really sort of set at the right level. But for the moment, the nationally determined contributions you can submit under the Paris Agreement, it's very wide open what they can contain. And certainly at the international level, there are no credible avenues for suing governments. It'd have to be domestic litigation, and that doesn't look terribly likely in Australia at the moment, though people are thinking very creatively about it, I have to say.
Can I just see a couple who's got hands, because they're sort of drifting a little bit in and out. Okay, so we've got 4 questions and 5 minutes. Yes, that was my first one at the back.
Saved by the gender, great. So I'm from an organization called Market Forces. My name is Bernadette. And our organization partly brings resolutions, this is part of our work, and asks questions at AGMs.
Yep.
One of the things we've been seeing this AGM season is that auditors have been saying it's not part of their job to consider climate risks. What suggestions do you have to hold auditors accountable when they're the ones that are meant to hold the companies accountable?
Yeah, that's really interesting that they're saying that it's sort of like a denialist position. We'll go and hide off in our turtle shell. We don't have to do anything on this. I think that that's a very risky position to take because of their role in signing off on financial statements and the increasing pressures, I think, around ensuring at least some credible information on climate risk. So if directors can be sued, I don't know why auditors would think they can't be. So I would be putting the Noel Huntley opinion in front of them and getting them to go through and justify why they don't also sit in that particular category. Because I think that the risks for them are just as substantial, if not more, because in many cases they're going to be an easier target to sue than company directors who have more discretion, if you like, around associated with the business judgment rule to sort of say, well, we weighed these risks and then we thought about these other concerns and we reached this very reasonable decision. Whereas auditors, it's that hard question of, okay, well, how have you valued the assets? Is that actually a reasonable way to value assets in light of this information that we have around climate scenarios and around carbon budgets and the risk of particular assets becoming stranded? So I think they're more vulnerable, but they might be in a position of denial at the moment based on legal uncertainty, I guess.
Okay, so we have the 3 remaining questions. If we're going to try and get them to be as short as possible, and I'll take them together, and then Jackie can do with them what she will,
Okay.
what she will, just to make sure that we finish on time. So we'll go back first, and then down here, and then down the front.
Yeah, Jackie, thanks very much for the presentation. It's been terrific. My name's Tony Gleeson, grandfather of 4 and climate activist. For a number of years now, I've been hearing that there's lots of creative work going on around litigation in Australia. So I see it as being I don't have any legal background, but I see that as being something that's really going to rattle some cages. Is there any attempts being made to gather the various people together and talk about it and tease out these creative ideas that are apparently percolating around the place?
Okay, I think I'm taking several
So I'll
questions.
take the 3 all together. So go there. And then Tim.
Hi there, Patrick Burke from Risk Solutions. We're brokers in weather risk transfer. Thanks for today. My question is whether there's a distinction to be drawn between climate risks and perhaps the political risk arising out of it, and different views on best actions to take as a result, which then might affect businesses and directors and officers' duties and trying to predict which way the wind's blowing.
Yeah, I'm Dimitra Fleur, PhD student here at college. Just a question maybe related to the question around suing the government. What are your options as a court or plaintiff if the companies do everything right, they report everything correctly, but the law is proven to be inadequate? And so the way that emissions are, for example, reported is proven inadequate.
Okay, so quick comment in response to each of those questions. Tony, yes, there is a lot of creative thinking going on around climate litigation and regular roundtables to try and bring the stakeholders together, both in Australia and in conjunction with groups in the US, the UK and Europe. There's a sort of momentum building, but in Australia there are some major risks for groups around costs. In other words, having to pay the other side's legal costs if you don't win. And also the political climate and our politicians who often do things like strip environmental groups of their funding if they're bringing these kinds of cases, not to mention the experts who are involved and the lawyers who are involved being vilified. So there's some real risks, and I think what's going on at the moment is some strategic thinking to try and think where's the best sort of place to put our money. On the political risk issue, this is sort of what's discussed in the context of transition risk and legal risk. So are we going to see new regulations come in that require either different kinds of disclosures or different requirements around what you do with greenhouse gas emissions? So that's definitely part of that discussion, and companies to date have been able to skate through a lot by being able to say with absolute truth that the policy environment in Australia is deeply uncertain, and so they have no certainty over what the 10 to 15 to 30 year time frame looks like. I don't know, I don't have a crystal ball to know enough, and I've stopped making predictions on whether the next energy policy of revolution, what's it called these days, the NEG, will come into being. So that actually the political risk or the sort of transitional risk associated with new regulatory requirements in Australia is not as significant as it is on some other jurisdictions. Though I think it might be more at the state level that we're going to see those innovations emerging in Australia at the moment. And then the final question, what can you do if the law isn't good enough? The answer is that that is definitely political avenues. So the law can only take you so far. And we've seen in the environmental area, for example, that we don't have strong environmental laws to deal with climate change. And no matter how creative you are about saying, well, you should take climate change into account under our general environmental laws, it doesn't always get you to the goal of stopping, say, the Adani Carmichael mine. What's interesting about the corporate law environment is that some of these questions have been untested. So to what extent do corporate law, sort of stock standard disclosure laws, actually require you to do something about climate change to make that information more transparent? And there's quite a lot of good legal opinion, as I was saying, that suggests that, well, actually you do. So if companies are more transparent, will that change behaviour without needing to change the laws? That's all I have to say.
Okay, so thank you so much, Professor Hill, for the presentation. Fantastic. I'd just like to again draw. This is actually I'd just like to draw everyone's attention quickly again to our 3 upcoming seminars before the end of the year. Before the end of the year, yes, all before the end of the year. So on Wednesday we have a presentation from our Canadian visitor Nathan Lemphers, who is talking about critical test of the carbon curse, comparing 3 high emitting or high exporting high exporters of fossil fuels, Canada, Norway, and Australia. On the 30th of November, we have a PhD confirmation seminar from Kennedy, who I can't see at this, he's down the back, who is talking about understanding variations in environmental governance through preferential trade agreements. I've seen a preview, it's a pretty good one. And that's on this Thursday. And on the 13th of December, we have Chang, another of our PhD students here, talking about least cost abatement from Australia's NEM, a generation and transmission co-optimization approach. Thank you so much for joining us today. And thank you again, Jackie, for your presentation today.